So today I want to talk about farm workers, unions, and the Supreme Court. The Supreme Court ruled on June 23rd that a California regulation that allowed unions to enter onto commercial farmland in order to speak with workers was unconstitutional, as it is now considered to violate the property rights of employers. This is yet another example of the United States treating property rights of business owners as far more important than the lives and needs of people who perform the bulk of hard work and labor. This new ruling undermines the historic work of the United Farm Workers under the leadership of those like Dolores Huerta, Cesar Chavez, and Larry Ittalong. The ruling also specifically targets unions in a very broad way that ignores the potentially larger impact and potentially dangerous impact that this ruling could have on how we view property rights and regulation itself. Now, the original law in question, the regulation law in California, essentially granted unions access to commercial lands for 3 hours per day, up to 30 days in a row, but never totaling more than 120 days in a year. This was done so that the unions could get access to and speak with workers at either an hour before their shift, an hour after their shift, or during their lunch break, those being the 3 hours they were permitted on the land, in order to assist them and potentially reach out to them about organizing a union. Now, this position was actually backed by a rather conservative Supreme Court ruling, NLRB versus Babcock, and this ruling is one that essentially stated that if you did not have access to workers on the property in which they worked, if that was the only way you could reach them, that is something you could do. As long as there were other ways to reach workers via other forms of communication or through their living quarters in a different location, then you did not necessarily have to be granted access to, say, a worker on the plant grounds. So because of this ruling and the position of farmers, with farmers often living on and working on the land that they are on and not having a separate living quarters where they can be reached, there was an exception made under this same idea in this ruling, where people in the unions could go out to farmland because it was the only way to properly access workers. Now, of course, there was a justification against that from Cedar Point Nursery and Fowler Packing Company, where they challenged that these laws and ideas were outdated, given that unions can now reach workers in many ways, including smartphones and radios, which is absolutely absurd and ridiculous. A lot of these cases, even if we assume that workers have cell phones, a lot of these places are in very rural areas where self-service can be spotty, and they are actively appealing to something that doesn't necessarily have a grounding. And as the UFW, the United Farm Workers, told the justices that the regulation from that ruling is actually even more important now than it ever was. The union said farm workers are increasingly indigenous workers from Mexico, and the only effective way to communicate with them is in person at their job sites, as many don't have a cell phone and only speak indigenous languages. A lot of these workers are living in labor camps owned by the employer, are transported to and from the work sites, and these folks are isolated. UFW Director of Strategic Campaigns Elizabeth Stratter said they never leave their employer's property. In some instances, they are isolated by design. Now, I don't have to tell you the implications of what a set of isolated workers looks like. There's nothing stopping, in these circumstances, something from exploitation in the form of maybe like a company town being enacted. There's nothing regulating whether or not these workers are being treated in any way fair, respectful, or with any sort of dignity. They are literally being isolated so they can't form a union and they can't communicate with the people around them. That is, by definition, kind of an abusive situation. The workers should be allowed to bring people on to talk with people and to interact with people outside of their employment space, and to do so with union members who might represent their interests, especially if they choose to do so. And again, the implications of this isolation is disturbing. Nobody should be isolated by their employers. The power dynamics are ridiculous. And I don't even want to go into the full extent of details on how that can go wrong. I ask you to use your imagination and look it up. But the current ruling of Cedar Point Nursery versus Hassid brings us into a very bizarre place in a conversation about property rights as well, in addition to all of these issues around isolating people and isolating workers and the harm that that can cause. The plaintiffs in this case argued that the ability for unions to enter onto their land without compensation violated the taking clause of the Constitution's Fifth Amendment. Essentially, what they were arguing is that because of part of the sanctity of property in the United States is the ability to exclude people from accessing it, and that the government here has essentially violated that right by denying the right of exclusion to property. They are in fact enforcing a taking on the property and limiting the ability for the owner to utilize property in a way that suits them. Now, just so we grasp that, it's being understood that people coming onto their land to help organize people is somehow taking from the property rights of the people, but the exploitation of labor through the capitalist system is not in any way taking anything from the workers. Just so we're clear on that kind of hypocritical position. But there are two typically recognized forms of takings that can occur when government interacts with business on behalf of the public. The first one is known as per se, and the second one is known as regulatory taking. The per se form is when the government appropriates lands for public use, and the government is therefore required to compensate for the loss and value of land. If the government says, well, we need this little piece of land to put something on it or to make some sort of regulation happen, then they have to pay in compensation some value to the owners of a business, and the businesses then are compensated and give up that land. However, a regulatory taking acknowledges that they are taking away some of the ability for people to exclude who comes onto the property, but it is designed specifically for institutions that might have some sort of interaction with the public, even in a distant way, such as a farm that produces food that will eventually end up on people's shelves, because we need to have health inspectors come into these properties. If you own a restaurant, for example, you might be asked to have a health inspector come onto your property, and that is seen as a regulatory taking. You do not need to be compensated for that, as it is the government assuring and protecting the public from the situations that could be going on in your business. Essentially, the government is doing a service in a lot of ways in that regard. Well, when we examine this current decision, we actually find that Justice Roberts' opinion didn't eliminate the distinction between regulatory and per se takings altogether, but it significantly blurred the line. As I said before, these two were considered as very distinct and separate categories of takings. You're either having the land appropriated, it's being taken in by the government now owns it and is using it for public sources, or the government is coming in to regulate it so that the public remains safe. In this instance, though, the line is now being blurred. Under the new rule announced in Cedar Point, any law or regulation that appropriates a right to invade private property amounts to a per se taking. If California allowed union organizers to enter an employee's land for a single minute, then California committed a per se taking, meaning that the company had to be compensated. This right to exclude is one of the most treasured rights of property ownership, Roberts writes, and much of his opinion suggests that any intrusion on this right to exclude amounts to a taking. Now, again, the issue of this comes into play when we consider the example of a restaurant. Suppose, for example, that a restaurant has a disgusting rat-infested kitchen that violates numerous local health ordinances. The restaurant's owners obviously do want these violations to be discovered. The restaurant's owners do not want these violations to be discovered, so they refuse to admit any government health inspectors onto the premises. Under Robert's reading of the takings clause, it's not clear why the restaurant owner should not be allowed to do so and effectively deny healthcare inspectors or health inspectors from coming onto the property, or why it shouldn't be able to, at the very least, demand compensation from the government before the health inspectors are allowed onto the property. Indeed, as California warned in its brief, the expansive vision of the takings clause laid out in much of Robert's opinion would also imperil a wide variety of health and safety inspection regimes, including food and drug inspectors, occupational safety and health inspections, and home visits by social workers, as well as a federal law providing that underground mines must be inspected at least 4 times a year. So the law is literally contradicting itself, because it's at the same time stating, well, you need to be able to send regulatory agencies into underground mines 4 times a year, but you're not allowed to make laws about unions being allowed to go onto the property. And of course, in reaching this conclusion, the court is essentially holding that unions are in some way different and separate from all of the other institutions involved. I'd argue that they are very much not, but that's at least the case that they are trying to make, which tells me that this decision was made beforehand and they looked to justify it retroactively. Now, this bizarre consequence of rulings makes it so that these really important agencies like health inspection, fire inspection, emergency medical personnel could be barred from entering into a place without financial compensation. And oddly enough, as I said before, and as I read before, this would also potentially extend to union organizers. Which brings us into the question of what happens now. There is one potential silver lining for the unions impacted by Cedar Point. The takings clause does not forbid the government from restricting property rights. It merely requires that the government compensate property owners when it violates the clause. And it's not at all clear how much compensation the farm owners should be due here. Indeed, at oral argument, Barrett suggested that farm owners may only be entitled to as little as $50 to compensate them for the cost of having people present on their land whom they'd rather exclude. A union that enters onto a work site might also successfully unionize that site. And an important question to ask with all of this is if they secure a collective bargaining agreement that requires the employee now to pay hundreds of thousands of dollars in additional compensations to its workers, does the state have to compensate the employer for all those costs? And that is an absurd statement. It really is, the idea that you would not only allow for the union to come in and you'd have to pay for the union to be on the property in the first place, but then to take it a step further, if the union were to ever achieve some sort of actual collective bargaining agreement on the land, that they would be responsible in any way, shape, or form for the additional costs of the business. And the fact that we are conceiving of this possibility tells me that this has gone in a very odd and strange direction, not just from the regulatory side about health inspectors and all that, but even from the union side itself, where the government might have to subsidize businesses for allowing a union to exist and paying that cost, effectively creating a social safety net for businesses and welfare. That doesn't sound very fair. I mean, it happens to larger corporations all the time at the cost of workers, so we really shouldn't be surprised that this is the direction the United States might be headed. So this does need to be recognized for what it is, though. This is really becoming an effective extortion of the state by these businesses, where the question of public and private is being called into question in really bizarre ways, and the issues of property rights are being called into question in really bizarre ways. The right to unionize is guaranteed under law, at least in most instances. And while there are exceptions, those exceptions do not apply here. and in a location where workers are effectively living on the property of their employers, I feel as though unions should at least be able to be recognized as a regulatory body and to be able to go in to the land, especially when workers are being isolated and are effectively being put in precarious positions in that regard. I would take it even a step further and acknowledge that if people are working for a company, then the company has effectively allowed the public into their land. When you have a worker, you are now engaging with the public, with somebody else who is now coming into your company. And therefore, you should be allowed to have yourself opened up to inspection and to make sure workers are not being exploited, especially on a property where they are essentially isolated for most of the year. Even further, I would argue that people living on these properties where they work should have a right to have people come visit them if they choose to, and should have a right to have people come onto the property that they are currently occupying and talk to them. Perhaps not during the hours of their workday. I understand why that could be something that a business and the workers might not want, but during off hours, for sure, the union should have a right to come onto the property whenever they deem it fit, especially if the people involved choose to let them do so. The problem with all of these new clauses and rulings, especially in this very conservative Supreme Court, is that property rights of the business class are always being protected over those of the workers. The ability for workers to speak out against exploitation, to control their own lives, and speak out against the ways in which the businesses control their lives is vastly ignored. People should have a right to speak to a union and organize without the state having to supplement a business's income. It's an absolutely absurd and ridiculous proposal that anybody have to be paid for somebody to come onto their property to try to create a union when there's no other true way to access these workers. And none of this is getting into the ways in which workers are not being compensated for the true amount of work that they put in, especially if we consider surplus value that the owners take. Instead, we have a Supreme Court that is much more worried about isolating people and keeping them in positions of limited power and preserving the status quo of a capitalist exploitation by making it impossible for unions to reach people no matter what the other costs of this justification are, including the ability of health workers, of health inspectors, of fire inspectors, and so many more being able to reach properties in a regulatory capacity. This is an absurd ruling. And honestly, if this is the direction that we're going, labor is going to have to fight twice as hard to overturn all of this. And it really does show how partisan and how specifically designed the Supreme Court is to uphold this portion of the status quo. The ruling was done 6-3 in favor of the Republican position, and it went straight down party lines. That's not a coincidence. So with that said, if you like this video, give it a thumbs up and hit the subscribe button and bell for notification. You can follow me on Twitter and check out my Discord in the description down below. We have lovely conversations there all the time. You're more than welcome to join us. That said, my name is Anarchist Tara, and I thank you for watching.